For latest updates, subscribe to our channel and press the bell icon.
Hello everyone, my name is Viren Dayal. I am a custom broker and a logistics skill council certified trainer in customs law. And today I am going to talk about a certain topic, a certain rule which makes it mandatory for banking companies or such other public sector undertakings to furnish information while investigations are taking place, when the goods are seized and are liable to confiscation. So under the Custom Act, as you are aware, a civil liability exists and a criminal liability exists. So the investigating officer has to collate a lot of information and prepare an offence report and then table it to maybe the Commissioner of Customs or such adjudicating authorities. And such reports should be factual in nature and should bring out what is the reason why the goods should be confiscated or the person should be liable to penalty, fine, as the case may be. While a lot of information can come from the importer, exporter or the custom house agent or a custom broker, many a times information is required from such banking companies, insurance companies, financial institutions, electricity companies and a host of such companies which are covered under section 108A of the Customs Act 1962. The custom officer, the investigating officer has got a right to ask for this information so as to complete his investigation and make certain points about how maybe monies could have been withdrawn, how they were remitted into India, then what happened next. So all these have a lot of bearing on the, not only on the alleged maybe smuggling of goods or confiscation of goods, it can also have bearing on other allied acts like FEMA, COFEPOSA and so on. Hence the custom officer writes to all these various agencies, banking companies, insurance companies, seeking certain information within a stipulated time and with an extension of 7 days or 15 days in case that particular information is not provided. Now here in these rules, it is mandatory for that particular banking officer, as an example, to furnish all the complete information, not piecemeal but complete, so that the investigating agencies can then logically conclude their case and take the matter further at their end. Now if there is a delay by all these banking companies, insurance companies to furnish the required data asked by the proper officer, then under section 108B, such officers or officials of these various insurance companies and public sector companies from whom data has not been received or has been part received will be liable to a personal penalty of ₹100 per day till they actually furnish the data from their records. Accordingly, in the Customs Furnishing of Information Rules 2017, so the name of that class of persons like banking company, nature of data required, from what period to what period, and the receiving authority here would be the investigating authority like DRI as an example. That is Director General of Revenue Intelligence is the receiving authority. So the banking company or the other companies which have been written, which have been mentioned in section 108A are under an obligation to furnish this, otherwise face penal action. So this is the scope and ambit of section 108A and 108B, and accordingly the rules have been made in this regard.
For detailed learning of all logistics subjects, visit www.logiveda.com.